going now. So thanks everyone for joining and welcome to this webinar where we'll be looking at the 5 key steps to help achieve a fair recruitment process. So just a bit of housekeeping before we get started. The webinar is being recorded, as you'll see, and it will be circulated afterwards. You are all muted during the presentation, but there is an opportunity at the end to unmute yourselves to ask questions, or if you prefer, you can put your questions in the chat box. Just be aware that the chat box is visible to the other attendees, so if your question is confidential or it's more specific, you may prefer to email me at the end and I'll come back to you. So I'm Simran Lally and I'm an employment solicitor at Grant Saw. I work with our head of department, Michael Pope, and paralegal Lauren Smith. So Michael Pope is also on today's webinar and he will be answering some of your questions later in the session. Just a little bit about the work that we do for employers. So we advise on contentious and non-contentious employment law and HR matters. This includes defending employment tribunal claims. We advise on redundancies, restructures and TUPE, disciplinary and performance management matters, and we review and draft contracts of employment, staff handbooks and policies. So this webinar is the second in our series of monthly employment webinars. Last month we were looking at the topic of long COVID and whether that may be a disability under the Equality Act. This recording is available on request in case you missed the webinar last month. The aim of these webinars is to keep you all updated with the ever-changing world of employment law and to make sure that you're well equipped to deal with all eventualities as business leaders and HR professionals. So today is all about recruitment. The news has recently shown that recruitment is at an all-time high, and it can really be a legal minefield for employers. And like most of your other business activities, it does need to be carefully considered and properly planned out to ensure that it's successful and of course fair. The potential for discrimination does exist in almost all the activities which are undertaken during a recruitment process, and HR and line managers need to be aware of these potential pitfalls. So just an overview for today, we'll be looking at what sort of legal issues can arise during the recruitment process, the practical steps you can take as employers to ensure that you're complying with the law, and then we'll be leaving you with some key takeaways and some tips to help you get going with recruitment, and then we'll have a short Q&A at the end as well. So the legal issues in the recruitment process, there isn't really one single act that governs recruitment and selection. There are quite a few statutes that have an impact on pre-employment issues. The most significant is the Equality Act, and that's the one that I'll be focusing mostly on today. So the Equality Act does make it unlawful for employers to discriminate against job applicants and of course existing workers and employees because of one of the protected characteristics. So as a reminder, the protected characteristics are age, disability, gender reassignment, race, religion or belief, sex, sexual orientation, marriage and civil partnership, pregnancy and maternity. So employers must not discriminate or victimise a person, either in the arrangements that they're making in deciding who to offer employment to, as to the terms on which the employment is offered, by not offering an individual employment, and they must not harass a person who has applied for employment. So as well as discrimination, it's also important to be aware of your obligations with regards to data protection. So when you're collecting personal data about a job applicant, just in the same way it is with employees, you are obliged to provide each individual with information about the data that you're collecting and using. This does include information about the purpose for which the data is being processed and the legal basis for this. You must also provide this information at the point in which you're collecting it, regardless of whether that job applicant actually asks you for it. There are additional provisions which apply to personal data of a sensitive nature, so this is referred to as special categories. This can relate to things like criminal convictions if you're collecting data of that kind, or medical information. So as well as discrimination and data protection, there are a few other important legal issues to be aware of, although I will not be going into much detail on them today. But you should be aware of the treatment of candidates with past convictions and the need to carry out a DBS check for those who will be working or dealing with vulnerable people or children. You should be aware of the limitations of employing children, so always be aware of the age of your job applicants. And then lastly, the need to check the right of the selected candidate to work in the UK. There is a statutory code of practice which can be used in tribunal proceedings and taken into account by tribunals when they're deciding claims about recruitment. So this was prepared by the Equality and Human Rights Commission, and it is a really useful document. So it's called the Employment Statutory Code of Practice, and Part 2 of this code sets out the recommended practices on recruitment, and the underlying message of the code is employers should be open to promote their employment opportunities to a wide pool of candidates to ensure the access to the best talent is available, and they should follow a clear and objective selection process, avoid stereotypical assumptions of who is likely to be the best candidate for their role. So throughout this webinar, I will be referring out to the code, and it's this code that I will be speaking about. So then we move on to the 5 key steps with the key legal issues in mind. So firstly, you need to look at what is the best method for you in terms of recruiting. So employers can use a wide range of different methods to attract suitable candidates, but this is all very dependent on your business and the role that you are hiring for. So the code does recommend that you adopt a standardised process if possible, and I've just popped up on screen the main recruitment methods. So this does include word of mouth, internal recruitment, online job boards and websites, recruitment agencies, press advertising, social networks, recruitment events. So employers should consider the medium in which their advertisements are placed to ensure that they are reaching a wide range of applicants. For example, if you're only recruiting via the internet, you may not reach a demographic that do not have access to the internet or struggle to use it. You may also decide the method in which you would like to receive the applicants. So applications. So there's either application forms or CVs. So application forms can be easier to sift through as you're able to go through them relatively quickly and focus on the most important areas of the form. And you can compare these answers in the first instance and then go on to the remaining questions for those who have made it through that first sift. There's also a useful way using application forms to obtain specific information because it's of course you who is drafting the form. So any particular questions that you want to know for that role, you can add them to the form and you can get exact information that way, which you can't always get from a CV. CVs can be seen as a little bit more informal, and they do give candidates an opportunity to showcase some personality because people do play around with the layout, their fonts and the structure of their CV. However, some candidates can be put off by the length of application forms, and therefore CVs can sometimes result in a larger pool of candidates as they do find it easier to simply send off their CV as opposed to completing a lengthy form. And with CVs, it can be difficult to compare them. As I said, application forms are quite easy to sift through them quite quickly, whereas CVs, because they do all have different layouts and candidates usually follow their own structure in respect of listing their work history and skills, it can be difficult to compare different candidates solely based on their CVs. You may even consider blind applications. So back in 2015, David Cameron announced that he would be introducing name blind recruitment for the civil service. And then after that, some of the big employers also started to follow this, such as HSBC and Deloitte. Instead of just removing names, they also removed other information such as gender, age, and some even removed universities to eradicate certain biases. As well as blind applications, more recently, artificial intelligence has also played a role in how you select your method for recruitment and how you choose your candidates. So this is increasingly being used. It can perform sifts of CVs and application forms. It can even analyse tones of voice or facial movements during interviews, and it can perform automatic filtering of candidates through online assessments and tests. So as mentioned, it really isn't a one-size-fits-all approach when you're thinking about what method you want to use for your recruitment. So things such as the size of your business, your resources, the vacancy and the number of expected applicants will all play a part in deciding what is best for your business. And in terms of when you're advertising for the role, so whichever platform you may decide to use, you really should be aware that inappropriate wording could give rise to discrimination claims, or it could be used as evidence of a discriminatory culture within your business. So just a few examples here. So look out for words which denote the masculine or feminine. So if you are recruiting for a waitress or waiter, make sure you specify both. If it's not possible, which it's not always possible to find a neutral term, you could just make clear that applications are welcome from all groups. You should also avoid, if possible, requirements for good use of English where it's not a specific requirement of the work to be done. You should also think about avoiding references to race, ethnicity and religion, unless these are genuine occupational requirements. For example, you might have an Indian waiter required for an Indian restaurant. With disability, avoid words such as energetic, where this is not needed to do the job in question. And just on the topic of disability, the wording of your advert should not suggest that reasonable adjustments will not be made for disabled individuals, or that they should not bother applying for a role. And then with age discrimination, specifying a maximum or minimum length of experience where there is not strictly necessary for the role could result in age discrimination. There has been recent case law where a vacancy for a teaching role was advertised as I think needing about 4 or 5 years experience, but then it was found that that role didn't actually need that length of experience, and therefore it was found to be age discrimination by the Employment Tribunal. So any questions on an application form about protected characteristics should always include a very clear explanation as to why that information is needed. And then once your deadline has passed for your applications, the next stage of the recruitment process is to select a preferred candidate from the group who have applied. So again, referring back to the code, it does say that wherever possible, you do have more than one person involved in shortlisting candidates. So some choose to appoint a panel to sift through applications by using an objective selection criteria. So using more than one person can remove the risk of one person taking an unbalanced view or an overly subjective decision about a particular applicant. When you have a panel, it also does encourage some healthy debate amongst those borderline candidates. And it can be time consuming having a panel. So this isn't always appropriate where you've got a smaller employer where they don't have the resources to allocate more than one manager to this task. So the panel should agree in advance the weighting to be given to any criterion that you're using, and the marking system should be agreed between you, and they should all be assessed and applied consistently. So it is best to agree on what would constitute a minimum score in order to qualify for an interview, and you should always know from the outset what's the maximum number of candidates to be interviewed, although I appreciate after sometimes shortlisting this does change. And selection should only be based really on the information that you're getting via application forms, CVs, or in the case of internal recruitment, based on a performance review or an assessment report that they've recently had. And to ensure consistency with this process, we would always say that the same staff, where possible, should be responsible for selection decisions in any given recruitment exercise. And it's very important these individuals are trained on your equality policies and in its application in the recruitment exercise. So the bullet point at the end where I've said keep good records, this is the one that is usually forgotten, particularly at this point. It is important that there is a record of the criteria that you use for shortlisting and how these were applied to each candidate. So the criteria must not be discriminatory, and you should really be looking out for anything which might show bias against a particular group of people. If this is done and you're consistent with your obligations under personal data and data protection in the shortlisting process, then if you are on the receiving end of a challenge or a complaint by an unsuccessful candidate, you should be a lot better placed to answer it if you have got good records. And then you move on to step 3, which is interviewing. So first, dealing with arrangements for interviews, again referring back to our code, this does suggest that it is good practice for employers to firstly, before you've actually arranged the interview, ask candidates whether they do need any reasonable adjustments in advance. And then usually on the day of, you could ask again whether anybody needs any adjustments. So you should ensure as far as possible that the arrangements for either your interview or whether it's an assessment centre or a specific test, that it's not putting anybody at a particular disadvantage who's connected with a protected characteristic. So the example here is where the dates of what you're organising coincide with, for example, a religious festival, or where you fail to take into account any dietary needs or cultural norms of individuals or particular groups. So once you've got your shortlist and this has been produced, you should consider whether, again, you're going to have an individual interviewing or if you're going to have a panel. You do come across the same issue with smaller employers where a panel just may not be practical or feasible, and with junior roles, it just may not be necessary to have more than one person interviewing. So you can reduce the possibility of discrimination taking place by ensuring that all your staff who are involved in the interview process have again had equality training and training about interviews in particular. This can help them recognise when they're making any stereotypical assumptions. In particular, there's a lot of unconscious bias which can take place, and it's always important for managers and HR to be aware of this. You should apply any scoring method objectively, and usually we'd say prepare your questions well in advance and base them on the person specification or job description that you're using for that role. And again, using the information provided only from the candidate's application form or their CV. And then I would say this is the most important point: avoid questions that are not relevant to the requirements of the job. So childcare, marriage, retirement, questions about personal lives are usually not relevant. Sometimes this information, especially if it's a more of an informal interview, it might just be volunteered and people tell you these things when you don't ask. But if that is volunteered and you do find out some information such as childcare arrangements, their plans to get married and so on, you should make sure that doesn't play a part in your decision making. So ideally, all candidates should be asked the same questions and scored consistently in an interview, but of course supplementary questions can be asked to clarify or explore the candidate's answers. During interviews, managers may scribble down handwritten notes or observation on interview papers, often giving little thought to what they are writing. These annotated papers will be subject to disclosure in the event of litigation. I think this does get forgotten a lot during interview processes. So we would say generally you should be discouraged from informal annotations. And what we've seen recently, which can be really helpful, is some employers are providing template forms to their managers and HR. So these forms have the interview questions on one side and then some space for comments. And this just makes it a lot more organised, and it avoids any kind of discriminatory notes being jotted down and then they could be subject to disclosure later. So importantly, again, do not make any promises during the interview process, and you try and avoid making job offers on the spot, regardless of how great the interview goes. And then at the conclusion of the interview process, you will have hopefully identified your star candidate for the role. If you haven't, at this point, you might decide to re-advertise in the hope of attracting new applicants, or some employers at this point look to restructure internally and reshuffle roles to fill that vacancy. So once you've got the successful candidate, you should be writing to them to make an offer of employment. So whether you've initially already kind of told them the terms verbally, you might then just be writing to confirm the offer. This can take the form of a letter of offer with a detailed terms of employment either set out within the content or attached. Some employers at this point, because last year in April 2020, there's now a requirement for employers to share a written statement of particulars for all employees and workers from the first day of employment, so on or before the first day. So some employers now choose, with their offer letter, they just attach the draft contract just so they know that they've complied with their obligations in that regard. So the offer should really include the job title that is being offered, any particular features of the job, such as whether it's fixed term, part-time, and the starting salary. You should also confirm whether, if you've had discussions beforehand and some things may vary in the offer letter, you should always set out that the terms of the offer do supersede any of your previous discussions during the interview process or after. You should also consider whether there's any conditions to the offer that you're giving. So the most common really is 2 satisfactory written references. Some employers do require medical examinations, proof of right to work in the UK, and qualifications, so evidence of their qualifications. You should also consider what timescale you're going to give for that applicant to accept. So whether that is signed acceptance of the offer letter, or you may ask them to return the signed contract. And then again, with our record keeping, do keep a copy of the signed offer letter or the contract on the file amongst the other personnel records for that particular individual. And then last but not least, we have step 5. So this is avoiding the pitfalls in the recruitment process. So I have highlighted some of the possible pitfalls throughout, but the key one I would say really is record keeping. So by ensuring that you keep evidence of good practice and your records, you should be better placed to show that you have taken reasonable steps to prevent discrimination or harassment. And in situations where litigation can't be avoided, you do then have a robust paper trail, which you can refer back to, and that will help in any proceedings going forward. So referring back to our code, it does suggest that every decision in recruitment is equally important as the other, and it just gives you a really helpful list of what you should have in your paper trail. So a lot of this is self-explanatory. So of course you should have your job description, your person specification, selection criteria, any written test and the results, notes of your shortlisting process, your interview questions, and together with the interview notes, minutes of any interview panel discussions or decisions following interviews. And I do think the last one is very important. So you should be keeping records to show that everybody involved in that recruitment process, whether it was the interviewing, the selection, whoever drafted the job description, has received the appropriate training beforehand. So training shouldn't just be done once, it should be done on an ongoing basis, particularly where you are about to have a big recruitment drive or you're recruiting for more than one role. You may wish to have a look at your training records and see if those managers involved, when was the last time they had training, and it may then be appropriate to provide refresher training before the exercise begins, and then do keep a record of the date that they did that training and retain that. So that's our 5 key steps to achieving a fair recruitment process. As mentioned at the beginning, it can be a bit of a legal minefield for employers, even when you have been recruiting for years. There are, of course, other areas to be aware of, but today we just focused on 5 in particular. So now I have placed on screen some of the key points and takeaways from today's session. So before you even embark on your recruitment process, you should be drafting a detailed job description and person specification. You should use an appropriate job title, accurately describe the job and focus on outcomes. And you should really be confident in explaining any of the requirements for the job. For example, you'd usually do get employers advertising for full-time roles, but then when their question as to why it needs to be full-time, they don't always have a sufficient answer or justification. And you should always be aware that this could be challenged by individuals who, for example, need to work flexibly because of caring arrangements or other commitments. So lastly, I do think, again, the most important takeaway is keep your good records. Even your scribbled notes could be admissible at some point. So when you are jotting things down, you're having discussions with other managers and amongst the panel, you're having a debate about a particular candidate, make sure somebody is documenting all of this in an appropriate way. So here at Grantsall, we can offer bespoke training sessions and workshops for businesses of all sizes to help you understand the law and achieve a fair recruitment process. We do also provide recruitment checklist template documents as well, such as offer letters, again, tailored to your business needs. So if you do have any questions about that or would like to find out more, do just let me know at the end of the webinar.